All right, so hi everyone. I am Melissa Daigle with the Louisiana Sea Grant Law and Policy Program. I want to welcome you to our webinar today. A couple of housekeeping announcements that will be included in the chat, just as a reminder. All participants are placed on mute automatically. If you do have any questions, please use the chat box or you can unmute yourself. Telephone participants can press *6 to unmute. And this webinar is being recorded, so that way we can post it on our Louisiana Sea Grant YouTube page. And at that point, it will include closed captioning. But do remember that any private chats do remain part of that recorded transcript. So just keep that in mind. So I'm going to introduce our team. As I said, I'm Melissa Daigle with the Louisiana Sea Grant Law and Policy Program. Also with the program is Nikki Pace and Jim Wilkins. And the COAST program is actually made up of 3 organizations, including Restore a Retreat, and Simone Malose is on the line from Restore a Retreat, as well as the Water Institute of the Gulf. And Jesse and Scott are on from the Water Institute. And so I'm going to go ahead and turn it over to Jim Wilkins. Jim is the director of the Louisiana Sea Grant Law and Policy Program. And he's going to be giving us a presentation today. And so, Jim, I'm going to make you host. Let's see. And you should be able to share your screen.
Okay. Okay. Can you see my slide, first slide?
No.
So I can see it on my end. Is anyone having trouble seeing it?
If it's a blue screen that says wetlands regulation, I see it.
Okay.
Yep.
All right. So the team thought it'd be nice if we just gave a little primer on wetlands regulation, since part of what we're doing is trying to educate people about wetlands and give some perspective. I think there's a lot of misunderstanding on how it works and why we do it. So why do we do it? Wetlands are incredibly productive food webs. We have they're some of the most valuable habitat on Earth. There's a lot of traditional ecological knowledge about them. We here in Louisiana, we know that a lot of our seafood bounty comes from wetlands. They serve as nursery grounds and reproduction areas and so forth. So, we kind of have an appreciation for them, but there are other types of wetlands as well. They're very varied. And the early Native Americans had extensive traditional ecological knowledge of wetlands, and their importance and benefits to human beings. They hunted in them and fished in them, gathered wild rice and other crops. European settlers tended to take a more utilitarian view of wetlands, consider them as a nuisance that should be converted to usable land, often with some disastrous consequences. Aldo Leopold, in his great work, A Sand County Almanac, describes how the bogs and swamps in Wisconsin were converted to hayfields, and how they burned for years afterwards because of the wrong-headed notion that you could turn those into crop fields. As I say, wetlands are very diverse. You find them in alpine areas, high in the mountains like this. I've seen a lot of these on my backpacking trips out west. You find them in deserts where they are gathering spots for all kinds of animals and the source of refreshing respite for hikers and things like that. Also, you see prairie potholes in the Midwest and the North that were left by glaciers that came down during the ice ages. And these are incredibly important habitats for waterfowl. So we have a very varied type of wetlands all throughout the country and the world. Of course, in Louisiana, we have more wetlands in Louisiana than any other state in the lower 48. And they're very varied in habitat type, cypress swamp, cypress tupelo swamp, bottomland hardwood, palmetto hardwood forest, and of course our fantastic coastal wetlands that we have more of than anybody in the lower 48. Of course, we haven't always been very careful about our wetlands. We have done some things that haven't been very smart in conserving and protecting them, and now we're suffering the consequences of that. So in 1970, only about half the wetlands remained in this country that were here in around 1600 when the first European settlers got here. So Congress, recognizing the importance of preserving as much of what we have left, passed the Federal Water Pollution Control Act, which is commonly known as the Clean Water Act. That was in 1972 under President Nixon. The goal of that was to have fishable and swimmable waters by 1983. We've come a long way towards that goal. We're not there yet, but the Clean Water Act has been very effective in a lot of ways in drastically improving the water quality in this country. Section 404 of that act regulates the discharge of dredged or filled material into the waters of the U.S. Actually, it says navigable waters, but then it's defined as waters of the U.S. after that. So why would the Clean Water Act regulate the discharge of dredged or filled material? Well, because that's the way wetlands are converted usually, is by bringing in fill, raising the elevation so they don't hold water anymore. And so that's why it regulates that discharge. It doesn't regulate merely draining a wetland, which we'll get into later. Now this act is administered by the Army Corps of Engineers with EPA oversight. EPA can veto permits if certain guidelines aren't followed, which we'll talk about in a second. So the two most contentious issues surrounding, well, let me back up for a second. So if a person wants to convert a wetland, they have to apply for Section 404 permit from the Corps of Engineers, even if the wetland is on private land. And this causes a lot of animosity from private landowners and a lot of frustration. And two of the most contentious issues surrounding Section 404 are what is a wetland and which wetlands are regulated. As far as the question as to what is a wetland, the physical determination is based on scientific factors. Hydrology, how often is it wet, what periods and so forth, the vegetation, do wetland plant species grow there in enough abundance that you can consider it a wetland. And the soils, does the soil chemistry say it's a wetland? This is primarily based on finding the soil is anaerobic or without oxygen because of its saturation all the time. There are also regulatory factors. And one of the regulatory factors is, would it be a wetland under normal conditions? So you can't just drain a wetland and then say, well, it's not wet, not ever wet. But under normal conditions, without your intervention, it would be, so it's still regulated. And there are some man-made wetlands that are also regulated. And the Act also covers wetlands that are intermittent. So the other question is, and let me back up for a second. It covers wetlands that are intermittent. So why would that be? Well, even though they're dry a good part of the year, they still provide the benefits that wetlands normally do when they are wet. That's why they're regulated. The second question, and the one that's caused the most legal battles recently, especially, is what are waters of the U.S.? And everybody agrees that tidal waters are covered under the Act. That would be the sea and seashore and waters up as far as the tide reaches. Waters that are navigable in fact, up to the ordinary high water mark, usable in commerce, or susceptible to use in commerce. Waters that are used for interstate commerce besides just navigation. Waters that cross state boundaries, and that has an interstate component, which constitutionally allows the federal government to get into issues between states. And wetlands that are adjacent to jurisdictional waters. And adjacency is the big issue now. Also, its classification of other waters. Now, these other waters are waters that are isolated, and they don't have a surface connection to navigable waters. They don't cross state boundaries. So those other waters are still wetlands and they're still important habitat, but under the Act, it was questionable whether or not the federal government could regulate them under its powers granted by the Constitution. So the agencies began using various vehicles to assert jurisdiction over these isolated waters. And one of the techniques they used was they call the migratory bird rule. And that said that if migratory birds use the waters for part of their life cycle, that the federal government can regulate those because those birds are important for interstate commerce, for hunting, for bird watching, and so forth. They have an economic value. So the federal government could regulate those wetlands under Section 404. The swamp case did away with that vehicle for EPA and the Corps. They said, no, you can't do it based on that. Then they started using a test which said that wetlands that they're isolated can be regulated on the basis of a seasonal surface water connection that were dry most of the year, or groundwater connections to jurisdictional waters. So if there was a wetland that's isolated, not crossing interstate boundaries, say mile, 2 miles, 3 or 4 miles maybe from a jurisdictional water, if that had a seasonal connection, in other words, with a wet season, there was a surface connection, they could still regulate it. Or if they determined it had a groundwater connection, they could regulate it. Well, that rationale was thrown out partially, at least, by the two cases, Rapanos and Carabel. And those were U.S. Supreme Court cases. And together, they said that that isolated wetlands could not be regulated under the Clean Water Act unless there was a significant nexus to jurisdictional waters. And that meant that that those isolated wetlands affect the chemical, physical, or biological health of the jurisdictional water. So how do you determine if there is a significant nexus? And that was a big problem. And the Obama administration went about, his EPA went about trying to go all through the country and catalog various water bodies and determine scientifically if they had this significant nexus that the Supreme Court required. And that was in process when the present administration came in and threw all that out. And so in April, they have promulgated a new rule determining what are considered waters of the U.S. under the Clean Water Act. And this new rule significantly reduces the scope of the Clean Water Act. It eliminates all isolated non-navigable wetlands and water bodies. It also eliminates ephemeral waters, which are only wet during or after precipitation events. And the state of Colorado was able to get the federal judge there to throw it out for the state of Colorado because they depend so much on snowmelt for their water and their habitat values there. So they threw it out in Colorado, but for the rest of the country, this new rule is supposed to go into effect. Now, there are bound to be lawsuits challenging this rule as not in compliance with the Clean Water Act's mandate to protect waters of the U.S. And depending on the results of the election in November, it could be totally reversed next year. So I would not depend on that being around for the foreseeable future, but it could be. This is just a graphic representation of some of the areas that were in the various cases that I described, and we won't go into that very much, but you can look at that later. Okay, so let's talk about some specifics of wetlands. There are some areas that are exempt from regulation. There are prior converted crop areas like cropland and non-cropland that have been converted before the Clean Water Act. Those are exempt from regulation. Waste treatment ponds or lagoons for municipalities that use wetland ponds or for tertiary waste treatment. Some ditches, they're non-tidal. Irrigated areas, rice fields are not regulated, and depressions that occur at construction sites are not regulated. So the activities that are regulated is the discharge of dredge or fill material from point sources. And that includes significant incidental discharge into waters of the U.S. So if there's a construction activity and they're moving dirt around and there's a lot of accidental or incidental discharge into waters of the U.S., even though it might not be intentional, that is regulated. There have been instances also where building docks and wharfs, and there's a pile, and the piling placement is such that it causes excess sedimentation on the water body or the wetland, that is regulated. And of course, the placement of fill for construction, which is generally what this is for, to elevate the land so you can build on it. So those are all regulated. Exempted activities, normal farming, forestry, or ranching are generally exempt from the Clean Water Act. Maintenance activities, things like levees, maintenance of levees or ponds, dikes, those types of things those are all exempted if they were existing at the time. Construction of temporary sediment basins. We know that some construction sites construct temporary basins to catch sediment before it goes into waterways, and those are exempt. And roads in association with farming and forestry. Incidental discharges. So if you're doing a job, say you're using a backhoe or a dredge, and you're dredging out something that's not regulated, but your dredge material falls back into a regulated water body. If it's only a very small amount, it's not regulated. Land clearing, this is a big one. You can go into a cypress swamp, and if you can avoid pushing the dirt around so that it amounts to filling the area, you can cut all the trees down without a permit, without it requiring a 404 permit. You'll need other permits, of course, but you would not require a 404 permit. Draining a swamp per se, or draining a wetland per se. If you can find a way to drain a wetland without depositing dredged or fill material, that's not regulated. Now, usually to do that and to make it permanent or to keep it from filling back in, you're going to need to put some kind of barrier down. Usually it's going to be an earthen levee, and that would be an activity requiring a permit. So you would have to get one anyway if you did it that way. And the exemption, there's an exception to the exemption such that if the real purpose is to change the character or the use of the water, it is not exempt from the Clean Water Act. There's a class of permits called general permits, and these can be issued for relatively minor activities, such as filling of no more than 25 cubic yards is one of the permits, and they have a minimal effect. But the key word here is cumulative environmental impact. This is one of the things that we see is an issue with everybody wanting to do just a little bit, and we have the concept of death by 1,000 cuts. So the Corps will look at if there is a cumulative impact of allowing a lot of these small projects to go forward. And these general permits receive an abbreviated, shortened review, so they're easier to get. Now, in the permit decision process, the Corps generally uses what they call their public interest review. And as you see there, they use a lot of factors besides conservation and ecological and biological factors. There are a lot of human-based concerns there, such as property ownership, energy, food and fiber production, mineral needs, and so forth. So they lump all of those together in their public interest review to determine what the cost benefit is for issuing permits to alter waters of the U.S. However, when it comes to wetlands, the Corps specifies a more stringent set of guidelines called the 404B1 guidelines. And those guidelines state that a permit has to be denied if a practicable alternative exists with less adverse impacts. And those alternatives are presumed to exist for non-water dependent uses. So what is a water dependent use? Well, it's a use that by its inherent nature, it must be on or near the water to function, such as a dock or a seafood processing plant, not a shopping center. And so, one of the most famous cases where the EPA has vetoed under 404C, vetoed their a Corps permit was a shopping center in New Jersey, which the developers wanted to put it in a wetland, and the EPA said, well, you had a chance to buy other property that was not in a wetland, and you declined to buy that. Therefore, these alternative was presumed to exist. You didn't meet the burden of proving that you couldn't do it anywhere else, so they vetoed the permit. Also, the 404B1 guidelines state that the permit cannot violate the state water quality standards or the Endangered Species Act or the Marine Sanctuaries Act. So another factor of the 404B1 guidelines is that the project must follow a sequencing process where the first thing is to avoid the impact altogether. Next thing is to minimize it. If you can't avoid it, then if you can't minimize it, you still have to repair it. And then if all of that cannot be done, you have, and you want to mitigate, that's how you get to the mitigation. There is a no net loss policy in the country right now, started under George Bush I, that says that every wetland acre must be replaced by an equal or greater value wetland area. And the way the Corps runs this is they prefer on-site mitigation and in-kind replacement of functions and values. In other words, if you degrade a high value wetland, high quality wetland, you have to replace the same amount of quality. So if you're going to replace lower quality wetlands, you have to do more acreage in that replacement. You also want it to be in the same geographic basin. And restoration of existing wetlands is preferable to creation because they find that restoration of existing wetlands function better than created wetlands. There are other agencies involved in the 404 process under the Fish and Wildlife Coordination Act. These three agencies, 2 federal, 1 state, are allowed to comment on 404 permit applications. And while they don't have veto power like the EPA does, their comments are taken very seriously and must be addressed by the Corps in their permit decision. A lot of times, the Corps will just decide not to go forward if there are strong objections from these agencies. Other agencies involved in the 404 process, the Office of Coastal Management, if the project is in the coastal zone, the applicant will also have to get a coastal use permit. So the Office of Coastal Management has to give consistency determination to the Corps that it's okay to issue the 404 permit. And one of the ways they do that is by issuing their own coastal use permit. If they don't issue the coastal use permit for the same project, they can deny consistency, and it'll have to go through a really stringent process there for the permit to be issued. Environmental quality, DEQ runs the Section 401 water quality certification program that the applicant has to get that certification or the 404 permit won't be issued. If the project is big enough, under NEPA, it's possible that we have to do an environmental impact statement. There's also the Wild and Scenic Rivers Act, which is on certain rivers, and if you're affected by that, you'll have to get approval from the Department of Wildlife and Fisheries. So there have been some pretty stringent enforcement actions. Both the Corps and the EPA have enforcement authority. They can issue compliance orders such as cease and desist and injunctions, civil and criminal penalties and fines, including, you can go to jail if you're, for knowing violations and trying to flaunt the requirements of the act. It can be pretty stringent. A unique feature of the Clean Water Act is it allows citizen suits, meaning that the plaintiffs, people who are aggrieved by the project and have standing because they are affected by it, can either sue the government for failure to properly enforce or administer the act, or they can sue violators for violating the act. That's an extra level of enforcement. There are other federal wetlands protection statutes, such as the Rivers and Harbors Act, which is mostly concerned with obstructions to navigation, but does have some wetlands protection effects as well. There's the Food Security Act, which is known as the Swamp Buster Act, which can deny farmers the ability to get crop subsidies if they convert wetlands to farm fields. And there's also the Wetlands Reserve Program and a number of other programs under the USDA, which will actually pay landowners, farmers and other landowners, for leaving their wetland habitat and other habitats in their natural condition, they can get perpetual payments from the government for that. So with that, I think I've probably worn out my welcome here, and I will open up to questions.
Thanks so much, Jim. So if you have a question, you can feel free to unmute yourself right now. And also Nikki Pace is going to facilitate any questions that you may have chatted in the chat box. So Nikki, I'm gonna go ahead and turn it over to you.
Yeah, so we have one question in the chat box, Jim, right now.
Okay.
It says, if you know that someone is engaging in activity without a permit and the area seems to be a wetland, what should you do?
Well, I guess it depends on how much of a snitch you want to be. You know, I would, if it was me, I'd probably notify both the Corps and the Office of Coastal Management, if it's in the coastal zone, notify them that there's something going on and see if there's a permit for it. Both the Office of Coastal Management and the Corps have field investigators that go out routinely and drive the roads. They also fly drones. They use aerial and satellite imagery to check for unauthorized activity. So they're always looking as well. But yeah, I mean, if it's something happening and you know you don't feel like you would get in trouble for for blowing the whistle, I would go ahead and blow the whistle.
Who would you recommend they contact? Would it be the Corps, or you mentioned the state office as well?
If it's in the coastal zone, the Office of Coastal Management in the Louisiana Department of Natural Resources would be the agency to notify.
And sort of a follow-up along that, do you know if they post issued permits on their website? So like if it was on a neighbor's property or something, could you go and find out if they had a permit if you were that interested?
Yeah, yes. I'm not as sure about the Corps website, but I know that the state website has really good tracking system for permits to find out, you know, down to the square foot where a permit's been issued and see if it's legit or not. It's called their Sunrise system, and it's open to the public.
Great. Those are all the questions we have in the chat right now, but everyone feel free to place additional questions there. You can also unmute yourself if you'd like to ask your question yourself. Let's see. Jim, I know you touched on the litigation around the water of the US rule. Do you foresee there being settled law on that issue anytime soon?
Oh, it's hard to say. I think the way the Clean Water Act is written now, there's always going to be some uncertainty as to what the scope of the jurisdiction is. You know, there is legislation that was been sitting around for a long time to just say, you know, all waters are regulated, and just to eliminate that that problem. However, I mentioned the Commerce Clause and the Constitution. You know, the federal government is the government of limited powers, and state governments are governments of general powers unless they're preempted by the federal government. So I think it was Justice Brennan maybe questioned in his opinion in Swamp whether or not the Clean Water Act could extend to all waters because of the limitations on federal power. So that would have to be addressed as well.
Let's see, so that seems to cover the questions that we've received so far.
And so I believe that Jesse from the Water Institute was going to provide some information on next steps for the project.
Okay. Sorry, y'all. Hold on one second. All right, there we go. Okay, so if anybody here from our host team still hasn't filled out the Maptionary survey, which I think we've got just about everyone except maybe 1 or 2 people, feel free to reach out to me with the link, and I'll send you the link so that you can get that done. But I think that's about it, if anyone else has anything.
So, and I'll just remind everyone that this is being recorded and will be placed on the Louisiana Sea Grants YouTube channel with closed captioning. Just, it'll give us a little time to get that up and loaded, but it will be publicly available. And Jim, of course, is a resource on this topic that he can be reached out to, as well as any of us members of the team if you have follow-up questions.
All right. Well, thanks everyone. Thanks, Jim, again for the great presentation. And if you have any questions, like Nikki said, just feel free to reach out. I hope everyone has a good afternoon.
Thank you.
Thank you.
Thank you. Y'all too.